Detail assistance, Vicky speaking. How can I help you?
Hey, we're at the west tip of Horn, and our bilge pump stopped working. We're sinking. Can you all please come? We have a membership.
All right, of course. How far is the work coming up, sir? Can you give me a description? Ankles? Hello?
Hey.
Yes. How far is the water coming up, sir?
It's coming up. We're just sinking. I don't know. Like we're going down.
All right. Well, let's get you going. Membership number or phone number listed on the account, sir.
I don't know the phone number. It's either. I think it's. Try that.
All right.
I know we have a membership, like guaranteed. I don't have the tag on
here. Unless you have a membership
number
or anything, it's okay. I'll get you over to the captain. What's the best phone number to reach you at?
Everyone in the background is saying, is he dead? Nolan, wake the up.
Claiming they're sinking and calling for help. And yet, in the background, are we really hearing all of this other activity?
Nobody has ever, none of the kids on this boat have ever admitted that anybody said that they thought Nolan was dead.
There is a sealed envelope on a district attorney's desk in Mississippi right now. What is inside that envelope decides whether Nolan Wells becomes a name in a courtroom or a name on a headstone. That envelope arrived on August 1st, and most of America does not understand what just happened. Everybody heard that the state autopsy on Nolan Wells was completed. Everybody heard that the results were sealed. Everybody heard the word sealed and moved on. That is a mistake. Because in criminal law, sealed does not mean hidden. Sealed means loaded. Sealed means the file is now in position to fire. Sealed means the trigger has been handed to a specific person in a specific office with a specific job description. That person is the Jackson County District Attorney. And starting on August 1st, this whole case is his decision. I want to slow down and walk you through what actually happened in the last 48 hours. Because reporters keep saying the same 3 sentences and moving on. And the 3 sentences leave out the one thing you need to know. Here is what happened. On July 30th and 31st, the state pathologist finished the state autopsy on Nolan Wells. That is the official government autopsy. It is separate from the independent autopsy the family paid for back on July 22nd. The state autopsy is the one that gets stamped, signed, and entered into the official case file. On July 31st, it was completed. On August 1st, it made the trip. That trip is short. From the medical examiner's office to the sheriff's office to the office of the Jackson County District Attorney. Small building, short drive, big meaning, because when a completed autopsy hits the DA's desk, the case leaves the medical world and enters the legal world. That transition is the difference between a death being called sad and a death being called a crime. NBC News reported inside this 48-hour window that foul play has not been ruled out by the state pathologist. Read that phrase carefully, not been ruled out. That is not the same as inconclusive. That is not the same as undetermined. Not been ruled out is a legal phrase. It means the medical examiner looked at the body, looked at the findings, and left the door open on purpose. That door only stays open when the physical evidence points toward a possibility the state cannot legally dismiss. For the family, that is a green light. For the DA, that is a homework assignment. Let me tell you about grand juries, because most Americans have never sat on one and only know about them from movies. And the movies get it wrong. A grand jury is not a trial. Nobody is found guilty in a grand jury. There is no defense attorney. There is no cross-examination. There is no jury of your peers deciding your fate. A grand jury has one job: look at the evidence the district attorney presents and decide whether that evidence is enough to bring formal charges. If yes, they hand up what is called an indictment. If no, they hand up what is called a no bill. That is it. Yes or no, the grand jury does not need to prove the case beyond a reasonable doubt. They only need to see enough evidence to believe a crime probably happened and a specific person probably did it. That is a much lower bar than a trial, which is why almost every case that goes into a grand jury comes back with an indictment. Prosecutors do not usually bring cases to a grand jury unless they already expect to win. That means the biggest decision in this case is not what the grand jury decides. The biggest decision is what the DA chooses to send to the grand jury in the first place. That decision is being made right now. Everything we have been talking about for the last month lands on that one question. Whose name goes in the file the DA hands to the grand jury? If the file has no name, no indictment is possible. If the file has one name, that person is going to be indicted. If the file has multiple names, multiple people are going to be indicted. Every option is on the DA's desk. Every option has a political cost. Every option has a personal cost. Every option has a professional cost. And the DA is the only person in Mississippi who has to weigh all of them at once. That is a very lonely desk to sit behind this week. Now let me tell you why the word sealed is bigger than most reporters have explained. Sealed does not mean the file is being buried. Sealed means the file is being protected. There is a legal reason for that. If the details of the autopsy were public before the grand jury saw them, a defense attorney could argue the jury was tainted. That argument alone could delay the case by months. So the DA seals the file. That is standard. That is how it is supposed to work. Sealed is a signal that the case is on the professional legal track, not off it. If this case had been closed, if the pathologist had ruled it an accident, if the DA had decided there was nothing to pursue, there would be no seal. The file would be filed. The case would be closed. Reporters would have a copy of the autopsy in their inbox by now. Instead, the file is sealed. That is not a red flag. That is a green light dressed up in caution tape. Every day that seal stays on the folder is a day the DA is doing something with it. Let me tell you what a DA does with a sealed autopsy in the days after it lands. First, he reads it himself, every page, every finding, every appendix. Then he sits down with his lead investigator. They walk through the physical findings against the statements the friend group gave the sheriff on July 5th. Every place the two do not match becomes a lead. Every place they do match becomes a bracket around the timeline. Then they build a working theory. Then they test the theory against the digital evidence coming back from the subpoenas. That last part is the piece that most people are underestimating, because the subpoenas that hit Meta, TikTok, Snap, WhatsApp, and Life 360 on July 28th and 29th are now producing responses. Those responses are landing in a lawyer's inbox right in the same window as the autopsy landing on the DA's desk. That is not a coincidence. That is a design. The digital evidence and the physical evidence are meeting in the same week. And when they line up, an indictment gets written. When they do not line up, more questions get asked. The DA is reading both stacks at the same time right now. That is his August. Now let me speak to the older folks who have lived through cases like this before, because I know some of you are getting weary. I know some of you are asking whether anything will ever come of all this. I know some of you have seen so many cases go silent that you have trained yourselves not to hope out loud. I want to give you one honest piece of information. In Mississippi and Jackson County specifically, when a sealed state autopsy lands on a DA's desk in a case with this much national attention, the timeline from delivery to grand jury decision is usually between 4 and 12 weeks, not years, weeks. That means the moment the world hears the DA's decision is very likely to come before the end of the summer. That is not a promise. Nothing in law is a promise. But that is a realistic window, and it is closer than most people watching this case realize. Every day that passes brings that window closer, not further away. Every day the DA does not make a public statement. The file gets more prepared, not less. The silence is not stalling. The silence is loading. Let me tell you what the DA cannot do. He cannot let the grand jury see the audio TMZ published. He cannot let the grand jury see the viral posts. He cannot let the grand jury see the YouTube commentators. He can only let them see the evidence his office has legally collected. That means the grand jury is going to see something completely different from what America thinks the case looks like. They are going to see the raw autopsy. They are going to see the raw digital records. They are going to see the raw witness statements. That is going to look different from the internet story. That is why the DA seals things, because the internet does not decide indictments. Grand juries do. And grand juries need clean information, not contaminated information. I want to point out one detail that most reporting has skipped. When a case moves from a sheriff's office to a DA's office, the person answering questions changes. That is a small piece of state procedure, but it explains a lot of what is happening in public. The sheriff no longer speaks for the case, the DA now speaks for the case, and the DA has not spoken publicly about the specifics yet. That silence is not laziness. That silence is a rule. Every public statement the DA makes in the coming weeks is a legal exhibit that could show up in a courtroom. So the DA does not make many. That is why every news update on this case sounds so thin. It sounds thin because the person who actually knows the answers is legally required to keep his mouth mostly shut. That does not mean he is doing nothing. It means he is doing everything, and none of it is on television. That is how the machine works. Now let me leave you with the piece that ties this whole thing together, because I do not want you to walk away with a bag of legal words. I want you to walk away with a feeling that matches the reality. Christine Wansley is going to sleep for the next several weeks knowing that a specific man at a specific desk is reading a specific file that decides whether her son gets his day in court. That man does not know her. That man has probably never held her hand. That man has probably never sat at her kitchen table, but that man is going to make the biggest decision of her entire life, and she cannot make it for him. That is a hard kind of powerlessness. It is the kind of powerlessness the older folks in this audience understand better than anyone. Because you have lived long enough to know that the moments that matter most in your life are almost never in your own hands. They are in someone else's hands, and you have to trust that person to do the right thing. Christine Wansley cannot trust. She can only wait, and she is waiting alongside every one of us watching this. Every day that envelope stays sealed, someone is making a choice. That choice is either to charge, to not charge, or to keep working the file until the answer is clear. There is no fourth option. There is no drawer the DA can put the file into and forget about. This case has too much national attention. This case has too many active subpoenas. This case has too many other government threads running through it. The FBI is now involved because of the bomb threats. The subpoenaed platforms are legally on the hook. The Wansley legal team is filing paper every week. The world is watching. The DA cannot forget the file. The DA has to move the file. That is the guarantee this week gave us. A decision is coming, not maybe, not eventually, coming. Watch for these three signals in the next 48 hours. A press availability from the DA's office, even a small one. A courthouse filing referencing the state autopsy. A shift in tone from Sean Tindell's office. Any one of those three signals means the file is moving. Two of them together means the grand jury is being scheduled. All three at once would mean an announcement is close. We are watching a case load itself in front of the entire country. The trigger is not pulled yet, but the barrel is loaded, the safety is off, the finger is on the trigger. The only question left is when. Every day that envelope stays sealed, someone is making a choice. And a mother in Mississippi is counting the days until that choice becomes her son's justice. Not weeks anymore, not months anymore, days, because the calendar has already turned. The clock has already started, and every hour that passes without an answer is an hour that a mother has to live inside the loudest silence of her life.